start then. Well, thanks for letting me come and present a little bit about estate planning. It's very exciting, but maybe not so exciting, but very necessary. So I'm an estate planning attorney. That means I set up wills, trusts, power of attorney documents. I help handle post-death administration, whether someone has a trust or does not. And we'll talk about what that looks like if someone has a trust and if they do not have a trust. But why don't we start with the will, what a will is. So a will is a legal document. It's basically says, I want my property to go to my children or charity or my friends. That's a will. That's what a will says. You sign it. There are witnesses who also sign it. And that's what will happen to your property when you pass away. It will go to those beneficiaries listed in your will. If you do not have a will, then by default, the laws of California have created a will for you, and that's called the laws of intestacy. Basically, what that says is you have no will. The state of California wants to know, well, who are your heirs at law? And there's a list that goes down under who will inherit first. So if you have a spouse, everything will go to the spouse. No spouse, kids, everything will go to the kids. No kids, what about parents? It'll go to the parents. No parents, it'll go to your siblings. No siblings, grandparents. No grandparents, your aunts and uncles. No aunts and uncles, then cousins and second cousins, third cousins. So there's like this table. So that's where your property will go if you don't spell out where it will go in a will. So I have a story about that. In our firm, long before I arrived, there was a client. He wasn't our client before he passed away, but after he passed away, we helped with his administration of his assets. And he had $50 million worth of assets. And he did not have a will, and he did not have a trust. So that meant that his $50 million would go to the first person who was alive on that list. And he didn't have anyone, no spouse, no kids, no parents, grandparents, siblings, aunts and uncles. And they found a first cousin who was alive. She lived in Bishop, California. She was 86 years old, but she is now inheriting $50 million. The second cousins heard about this and sued the first cousin. Now, they're not going to win the lawsuit because they're second cousins and the first cousin is alive, so it would inherit. But it didn't matter. The second cousins didn't care. They were going to throw everything they could legally at the first cousin in the hopes that the first cousin would not want to fight this legal battle and just settle for some of the 50 million. So she did, instead of fighting, years to try to get the 50 million, she decided, I'm just gonna let him have half, 25 million. I'll keep 25 million and live the rest of my life without having to fight this court battle. So anyway, that's just one example of what can happen if you don't write down in a will or another estate planning document like a trust what you want to have happen to your estate. So you have a will, great. You've said where you want your property to go. It's going to go there, but your assets are in your name individually. So because they're stuck in your name individually when you pass away, they have got to be, they've got to go through the probate process, which is a court process. I don't know if you've heard of probate, but it's a court process where the judge wants to supervise the administration of this individual's estate. And it's takes a long time, 9 months at least to a year or more for this process to go all the way through, and it's expensive. The attorney's fees for a probate are set by statute. The individual firms don't decide how much they will get based on the work they do for probate. It's set by statute. And if you Google probate calculator, it will show you exactly how much the attorneys will get by doing this work. And it's not just the attorneys. So during probate, the court appoints an administrator separate from the attorney who basically steps into the economic shoes of the deceased individual to distribute out the assets at the close of probate, but before that, to handle all the bills, the liabilities, the debts, to sell any property, to put the money into a bank account, to stay in the bank account until the close of probate. So someone needs to do that work. And so the court appoints an administrator. The attorney petitions the court to appoint this administrator. The attorney is the one who files all the documents with court, fills in all the forms. If there's a will, the attorney works with the administrator in procuring the original will. It needs to be the original wet signature will that needs to be lodged with the court. If there's only a copy, a photocopy, then the witnesses who sign the will need to sign documents saying, yes, this is the will, I was there. Well, when the deceased individual signed this. So there's a lot of paperwork involved. And if there's no will, the attorney has to work with the administrator in finding out who are the next heirs at law. And so there's a lot of paperwork that goes into that. It's a long process. It's an expensive process, like I said. So if the deceased individual had a property, then the court appoints someone to appraise the property, and that costs money. So all of the assets need to be listed so the judge can see exactly what this individual owned, whose heirs at law will inherit, or if there's a will, exactly what the will says. So it's a long process and it's expensive. So you want to avoid probate at all costs, but you want to avoid probate. It's very important. That's what estate planning attorneys really are for, is setting up legal structures to avoid this process. So there are a few assets that by their nature do not need to go through probate, even if they're not titled in, even if they're titled in the deceased individual's name individually. So this is, for example, cars. Your cars do not need to be titled in another legal entity. They can just stay in your name individually. And when you pass away, they'll be transferred via the DMV. They don't need to go through probate. You just go to the DMV, show a death certificate, you fill in a form, and the vehicles are transferred that way. Other items like tangible personal effects, like household items, those don't need to be titled in a special way. They are exempt from the probate process. Yes, up to a certain value. So if you have a really expensive antique item worth millions, I mean, that's different. But just basic household items are exempt. And there's a threshold amount that I'll mention. Bank accounts do not need to go, small bank accounts do not need to go through probate. But there's a threshold amount, like I said. So let's say you have a bank account with $150,000 in it. Well, that can go without probate because the threshold is $208,850 as of 2026. That's the threshold. So anything underneath that is exempt from probate. So your $150,000 bank account doesn't need to go through probate. Well, let's say you have $150,000 in one bank account, and a separate bank account you have 100,000. Well, individually they're below 208, but together combined they're above. So they both have to go through probate. So it's the aggregate. So all bank accounts that you own, if in the aggregate it's above 208,000, it's got to go through probate. So, yeah. I got some water. Thank you. So 208 is the threshold, even if it's individual bank accounts, if it's above that. Or so the number is 208,000 as of 2026. Everything that you have, if it's under 208,000, then it doesn't need to go through probate. But if it's above that, then it does. Mm-hmm. Yes, so you were asking about the other assets, life insurance, tax exempt, not sure what that was, but 401ks. I was about to mention that, yes, if that asset, maybe a small bank account, life insurance, 401ks, has a beneficiary attached to it, a beneficiary designated, does not need to go through probate. It automatically goes to that beneficiary. Yeah. Yeah. Right. Yes. So I'm not exactly sure the full process for that. But it doesn't need to go through probate for sure. So it'll be canceled. I just don't know the details of that process, but yeah, no, it doesn't need to go through probate. So yes. It does not. Great, that's fine too. So TOD, transfer on death, or POD, pay on death, for cash. Is one of the ways to avoid probate. So it's basically having a beneficiary designated on your account or on your card. It's gonna go to that person. So that's good. That's good.
I have a question. So no one can
Yes.
contest the beneficiary on the name named? No one can contest it?
Uh, so anyone can contest anything, but if if you go to the bank or if you go to the DMV or any institution where you have an asset, an account, and you fill out their form, writing your beneficiary, then that form will control, and anyone, maybe they'll come up with a form of their own, but that'll be for the bank. That's the bank's responsibility to verify that this is the correct form, this is the correct beneficiary that the deceased individual appointed. So I don't see, I mean, of course, there's lawsuits about anything, but if you go to the bank and you put a beneficiary on there, it's gonna go to that beneficiary. Leave it at that. Yes, life insurance. Well, life insurance usually has a beneficiary on it, but if not, uh-huh, if there's no beneficiary attached to the life insurance. Oh, okay. Mhm. Mhm. So still a ceiling, but if the life insurance has a beneficiary, it's over 208,000, but it has a beneficiary, it's gonna go to the beneficiary, no probate requirement. Same with the bank account. If it's over 208,000, but it's got a beneficiary, no probate. Yes, yeah. 208 is the number for all assets, yeah. Mhm. Yes. Huh? Yes. So,
And just before you speak, I was wondering if you could repeat the questions that people
yeah.
ask. I can't
So
hear
she
them.
asked,
Yeah, thank you.
so she's doing a will, she's writing a will, and she's wondering if she has beneficiaries attached to her other accounts, can she still write someone else in her will that gets the same beneficiaries? Okay, yes, so that's fine. So the will is kind of like a gap filler, um, if you want it to be. It can say, well, everything goes to these beneficiaries. Now you already have specific accounts going to those beneficiaries because you've put their names down at that institution. So it's gonna those accounts are gonna go to them. Anything else that you have that are not those accounts, that don't include those accounts, anything else will go to those beneficiaries that you named in your will. It does not create a problem if they are in the will and if they're already named in a separate account. It does not. So I just had a call recently with someone. Um, her parents passed away on the same day, and parents had life insurance, bank accounts. Um, it had a beneficiary designated, but it had each other named. So what happens then? Well, it's got to go through probate. Um, even if so, they had a beneficiary name, but that beneficiary did not survive the other. Um, there's a law in California saying you need to survive at least 120 hours to inherit, to be the beneficiary. So because they died on the same day, none of neither of them survived the other. So the beneficiary designations do not apply, and there's going to have to be two probates for both of their estates. So you name a beneficiary, you can also name a backup beneficiary to be safe. So that's at that institution that you do that. So us as attorneys, we don't do beneficiary designations on your accounts. You go to the bank, you contact the life insurance institution, and you put down your beneficiary. Yes. So with a handwritten will, does it require a medallion signature?
A notary?
Notary? So with holographic wills, they have special rules um, with that goes with it. I can't remember the exact rules, and I don't know if they have to have a medallion signature. Um, but that's something that can be found out. I believe there has to be maybe 3 witnesses and some special rules, but to be safe, you'll wanna do a typed will, the most ideal typed out will, and then you sign it and you have it witnessed by two people. Yes, that's correct. So with holographic wills, it's got to be in your own handwriting. Mhm. That's one of the rules. So there are different rules for that, for holographic wills, which are handwritten wills. Um, Chat GPT. Um, yeah. So those laws can be looked up. I can look those up and help you out with that if you'd like after this. But I mean, we do wills, we type them up and then the person signs them. That's how we do them. And I'll talk a little bit more about that. Yeah, I'll let you know the fees and everything at the end. So, but just moving on quickly to more ways that you can avoid probate. I mean, the big one that I want to discuss is establishing a trust, and I'll talk about that. But before that, I don't know if you've heard of joint tenancy. This is another way you can avoid probate. Let's say you have a property and you and your spouse are on the title of the deed of the property as joint tenants. So that means the law of joint tenancy says if one joint tenant passes away, the property automatically goes to the surviving joint tenant. So that avoids probate. You don't have to go through probate. The surviving joint tenant has the property 100%. But then if the survivor passes away, it's stuck in that person's name individually and it's got to go through probate. So before I move on, I want to explain a quick tax problem that happens in joint tenancy. So usually, say you buy a property at $100,000. Later, years pass, it appreciates to 200,000. You sell it, well, there's $100,000 of gain that you need to pay tax on, called capital gains taxes. And that's a high tax rate. So let's say about 100,000, it appreciates to 200,000. You don't sell it, you pass away. Because you've passed away, there's a special rule that says the tax basis gets bumped up to 200,000. So whoever inherits the property, when they sell it, the tax basis is not 100,000, it's 200,000. So they don't have to pay any capital gains. If it's titled in joint tenancy, there's two people on it. One joint tenant passes away, it automatically goes to the survivor. If it's appreciated in value, only the survivor's half will be stepped up. So the deceased person's half will be stepped up, and the survivor has to pay capital gains if they sell it on his or her half of that capital gains. So that's another problem with joint tenancy. Kind of complicated, but you don't need to really worry about that too much. You can ask them about it later. So the main way to avoid probate is establishing a trust. So this is the key. You have a will, great. It's not going to avoid probate. You have a trust and you transfer your assets to the trust, it avoids probate. So what's a trust? It's another legal document you sign. It's basically a contract, an agreement that you sign that becomes a legal entity, separate entity. There are some terms in a trust. The creator of the trust is called the trustor. The manager of the trust is called the trustee. The ones who inherit the property in the trust are called the beneficiaries. So, for example, let's say Mike Johnson establishes a trust while he's living. He's the trustor, the creator of the trust. He's also the trustee, the manager of the trust assets. He's also the current beneficiary of the trust. They're his assets. He's benefiting from them. He lives in his house. He manages his investments. He's the current beneficiary. Mike Johnson writes in his trust, after I die, I want my property, my investments to go to my children. When he dies, if he has transferred his property to his trust, the property is titled in the trust and not his name individually. So no probate, doesn't need to go to probate. No asset is stuck in his name. It's in this separate legal entity's name. And it just passes to the beneficiaries of the trust without the need to go through court. So that is huge. And it only works if you transfer title to the assets to the trust. So you have a property, you have a deed, has your name on it. You establish a trust. You also sign another deed saying, I transfer this house to myself as trustee of my trust. Your name is still on there, but in your trust. And you record that with the county. And now title is in the trust. And it is safe from probate. You have an investment account. You go to the institution, Morgan Stanley, whatever. You say, I'd like to title my investment account in the name of my trust that I just set up. They say, okay, great. Sign, fill out these forms, and you do. Now title in your investment account is now in your name as trustee of your trust. Safe from probate. You have bank accounts, you name beneficiaries, you have backup beneficiaries if you want. A backup beneficiary could be the trust if you want. Usually it's recommended that you name an individual as the primary beneficiary, but you can name the trust as a backup. Okay, great. So let me talk a little bit about some tax planning, just so that you are aware. So there's income tax, there's capital gains tax, there's property tax, there's a bunch of taxes. There are transfer taxes. Transfer taxes, if you give away money during your life, you could be, you could have to pay gift tax. If you give away property when you pass away, you could pay an estate tax. You give property to your grandchildren. You skip a generation. There's a special tax called a generation skipping transfer tax. And these taxes, the rate is 40%. So that's high. There are some exemptions to this. There's the annual exclusion amount, which as of 2026 is $19,000 per individual. So every year you can give from yourself to everyone in the world if you want to, each $19,000, no gift tax, because it's exempt. So let's say Mike Johnson wants to gift his son $19,000 for the year 2026. Done, no gift tax. He wants to gift his daughter $19,000. Done, no gift tax. Let's say he gives his son $19,000 in 2026. Let's say the same year, he gives his son another $19,000. Well, the first $19,000 is exempt. The second is now over the annual exclusion amount. So it is subject to the gift tax. However, there's another exclusion amount, a total amount for each individual for their lifetime. The year 2026, it's 15 million. So you can give in total 15 million worth to anyone. Now, Mike Johnson gives 19,000 to his son, exempt, 19,000 annual gift tax exclusion. He gives another 19,000, not exempt from the annual exclusion. It gets subtracted from his total 15 million. So now he has 14,981,000 left in his lifetime. So that's the gift tax. Same applies if you die and you give away, Mike Johnson passes away. He's got 2 million worth of assets titled in his trust, no probate, goes to his kids. Well, 2 million is below 15 million, so no estate tax that he has to pay. There's an equal generation skipping transfer tax exclusion amount of 15 million. So he gives to his grandchildren 14 million. Well, that skips a generation. So it's subject to that generation skipping transfer tax. But since it's under the 15 million, there's no tax. So what about spouses? You can give to your spouse an unlimited amount and there's no tax. There's a special marital deduction. Yes, so that's federal. It's a federal, every state. Yeah. There is no penalty for the recipient in California. Yep. So there's no inheritance tax. If you inherit money in California, you do not need to pay tax on that, tax free. There is an inheritance tax in other states. I think Washington is one of them, but I'm not sure the rest. But California, no. It's based on, yes, where the deceased individual resided. So if you have children in Washington, they inherit your money in California. When you died in California, there's no inheritance tax. Now they have it in Washington. They pass away and give it to their children. Their children are going to have to pay inheritance tax. In Washington state inheritance tax. So, okay. So there are a few advanced estate planning techniques that I'll just briefly mention because they get complicated. But you could, if you wanted to, give away your assets, 19,000 each year. That's one way to decrease your, let's say you have 50 million and you only have 15 million of exemption. So you want to protect the remaining amount that's not included in the exemption. Because if you pass away with 50 million, only 15 is exempt, and the rest you're going to have to pay 40% tax on. So if you want to avoid that tax, there are some ways that you can do that. Giving away your money is one of them. 19,000 each year to all your kids. You can give away your money to a separate trust. So the trust we talked about before is a revocable living trust. Revocable meaning you can revoke it or change it while you're alive. So Mike Johnson, he establishes his revocable living trust. He's alive, he's the creator, the trustor, he's the manager, the trustee, he's the current beneficiary, he's benefiting from all his assets, he's living his life. When he passes away, the trust gets locked, gets irrevocable, so it becomes unchangeable. The trustor has passed away. Mike Johnson has named in his trust a successor trustee, his brother, Steve steps in as trustee of the now irrevocable trust. Steve is in charge now of distributing out Mike's assets to Mike's beneficiaries. And in the trust, it says, my beneficiaries are my children, my son and my daughter equally. So Steve, as the trustee, the successor trustee, steps into the shoes of Mike economically, sells the house, distributes out the proceeds equally 50-50 to the son and the daughter of Mike. So that's what the successor trustee does. Us as attorneys, we assist in the trust administration. We help the trustee fill in all the paperwork that needs to be done. But again, the process to do that is way cheaper, way faster than having to go through court and the probate process if there's no trust. Yeah.
Dictate, should only one survivor, 100% goes to that survivor, but it verifies that's what would probate. Because, you know, obviously, gray area, you just have it saying, you know, only one survivor, then 100% to that person, or to be survivor, and that way it verifies that's what.
Yes, so what she asked was, if something happens to, your child and there's like a contingency, what happens to that child's share, perhaps? You say 50-50, but if that child's not there, then what happens to that? Well, yes, you can absolutely, you do, and we do, in our trust, we say, if this person is not living at the time of your passing, then it goes to that person's descendants, if any. If none, then it can go to the share of the survivor child. So there are contingencies that you write in there. Yes, you can. You can. You don't have to. Mhm.
So if I want it to go, like, if there's only one,
Mhm.
I didn't even think of that, which is part of thought, but it's to be
Yeah.
real. And so, do I need to dictate that in there? I'm just saying, you know, right now it's 50-50, but if there is one and it goes to just 100% to the other.
Yes, you can dictate that in there. Mhm.
So that would be biased even for baby.
Yes. Mhm. Yep. Yeah. Yeah. And that will be handled with the bank. Mhm. You go to the bank and describe that situation and they'll provide you with that form. Yes. Yeah.
Yes, they get one of each of the accounts.
Yeah.
So I was wondering, I can mention that, like I should have both of them. Instead of just one, or how do you do it with a POD? Do you put another person as a secondary POD, or what's the difference between a POD and, it's paid on death versus a beneficiary, which would be obviously when you die to?
Yeah, so there's really no difference. It's just a different name for the same thing. Yeah. So maybe the bank calls it a POD. Maybe the bank calls it a TOD, transfer on death. Maybe the bank calls it a beneficiary designation. It's all just meaning the same thing. You want it to go to this person upon your passing. Yeah. Yeah.
Doing it that way.
Yeah.
Because everything's tied into all the activities.
Yeah. Mhm. Right. Yeah. Absolutely. And that kind of goes into the next thing I want to talk about is power of attorney documents. So we also set up power of attorney documents. One for financial making decisions, one for healthcare related decisions. Now, a power of attorney document applies only while the individual is alive. Once the individual passes away, the power of attorney documents no longer apply at all. And also, the power of attorney documents don't apply to trust assets. They apply to assets outside the trust. So let's say Mike Johnson names his brother Steve as his financial power of attorney agent. And Mike gets into a terrible accident and is incapacitated. He can't explain his wishes or handle his financial affairs. Steve is the named agent. He steps in and is able to act on Mike's behalf, pay the bills to the house and all of that, so that everything is handled while Mike is no longer able to do that. He's still alive, but he's incapacitated. And also for healthcare, Steve is named as the healthcare agent. Well, then the doctors will ask Steve, you know, what do you want us to do? Let's say Mike is unfortunately in a coma, no hope of waking up, or very little likelihood of waking up. He's on a machine, keeping him alive. Just because of the machine, if they unplug the machine, then he's going to die. Well, Steve has that authority to make the decision, well, unplug the machine or keep it running. And so you want to name someone who you trust, who you want to make that decision, the decision that you would have made. You want to tell that person what you want. So you can also name someone on your bank account. You can be joint accounts, usually with your spouse, with your children. If you pass away, well, there's still an owner on the account, and that's your son or your spouse. So I just mentioned that as another way to avoid probate. And so those are power of attorney documents. Yes, you have a question. Yes. It could be. I mean, you can do both. You can do both. Not necessarily, no. So let's say you name someone else, your son or daughter, as equal owner on the account. Well, they can access the funds right now. They're an owner on the account. If you pass away, they're still an owner and they can access it, and they will have access to it. Let's say there's someone else named. Well, that person's not going to get the assets until the owners pass away, both of them. So just the order of it. Well, so executor is another term. It's the person named in the will as the person who you want to handle your personal affairs. Plan the funeral, take care of your personal items in the house. And usually the executor and the trustee, usually named as the same person, can take a fee for the work that they do. So to avoid that, to avoid the executor taking a fee from the work, yes, so the money that they get from working is going to be from your estate, is taxable income to them, income tax. So let's say Mike Johnson, he's got his trust, Steve steps in as trustee. The work that Steve does in distributing out the assets to Steve's children, Steve can get a fee for that from the estate. So he takes maybe 1% of the estate value, and gets paid. Well, that's taxable income to him. He's gonna have to pay tax on that. Now, let's say that Mike Johnson doesn't name Steve, his brother, as trustee. Now, well, before I say that, you can waive the fee voluntarily. You can say, I don't want to take a fee. Let's say Mike names his son as the trustee. And his son is, 30s when Mike passes away. Well, the son steps in as trustee, does all the work in distributing out the assets, half to his sister, half to himself as beneficiary. Well, he did all this work as trustee, so he's able to take a fee, a 1% fee. And there's no statute that says it's got to be 1%. It's just a reasonable amount, usually 1%. So he can, but he says, well, that 1% I have to pay tax on. I'm already beneficiary of 50% of all these assets. Instead of, taking a portion of that, paying myself, but having to pay tax on that, I'm gonna waive that fee because I'm getting everything anyway. That's usually what happens if your children are inheriting your assets, even though they are allowed to take a fee. They usually waive it. They say, that doesn't really benefit me to take that because I have to pay income tax on it. That makes sense? So, yes. Yes, so if you just have a will and no trust, the court wants you to lodge the will, the original will, with the court. So you've got to physically take the will into court, and they will keep it, and they keep it. They don't return it, and it stays with the state of California. If you don't have the original, and obviously you can't give them a will. They don't want a photocopy. And there's other documents, like I've mentioned before at the beginning, that need to be filed with the court to verify that this photocopy is the actual will of the deceased individual. So, Superior Court of California. In the county where the decedent passed away. San Bernardino, Los Angeles, Orange, Riverside. Yeah, it's only filed after the person passes away. Yes. Yes, and technically the law says when anyone dies, their will has to be filed with the court. Well, if they don't have a will they don't have a trust, they have a will, and it has to go through probate, well, the will is going to be filed with the court. If they have a trust, then the property is just going to go to the beneficiaries, and usually the will is never lodged with the court at any time because the court doesn't know that they even had a will, Correct. So if it goes through probate, meaning all the assets in the aggregate are above 208,000, then it's got to go through probate. Then you have to lodge the will. If it doesn't need to go through probate, then you don't need to lodge the will. Yes. Yes. So with those, let's say you have a small bank account of $100,000. You have a car, but that doesn't need to go through probate. But you've got this bank account, but it doesn't have a beneficiary attached. But it's under 208,000. So all you need to do is present the bank account with a document called a small estate affidavit. Basically a statement saying this is the deceased person's account, and it's gonna go to this beneficiary, their children equally. And the bank will take that, because it's underneath the threshold. We had a client who had a bank account worth $207,000 currently. When the person passed away, it was $225,000. So right now it's underneath, but at the time of death, it was over. So it had to go through probate. Correct. So we've got 5 minutes left. Any more questions? We'll end that. Yeah. Notarized, well, no, not notarized. Yes, signed, witnessed. Holographic will has separate rules. It's gotta be in your own handwriting. It's gotta be dated. The holographic will has to be dated. But the wills that we usually prepare are typed, and then it's gotta have your original signature. The witnesses have to be present while you're signing, and the witnesses also sign. Forgot to mention, the wills that we prepare a package of documents. We prepare the will, the trust, and the power of attorney documents, all as one package. The will we write up is a pour over will, meaning it says all of my possessions go to the trust. The trust is the beneficiary of the will. And then in the trust, you have your beneficiaries, your children, your charities, your friends, whoever you want. So the will is pouring over all your assets into the trust. That's the will that we set up. It's, just the law, I guess. Yeah. Someone decided, it's gotta be witnessed by two disinterested individuals. They can't be inheriting from you. Because they have then an incentive to, yes, I have this will, I'm inheriting. You know, disinterested, yes.
Verbiage without bail or without bond?
Without bond, yes. So, yeah, usually our wills say, we name an executor and the executor shall serve without bond. If it doesn't say that, and it's gotta go through probate, meaning the court is supervising it, the court will require the executor, person named in the will, to administer the person's estate, to post a bond, to make sure that the executor doesn't abscond with the money. Yeah. So we usually say no bond is required, just to make things easier on the executor. Because the executor is usually a family member, a friend, someone the person trusts. And we're helping them administer it. So, are there any other questions? Yeah. Any other questions? Okay, well, that's about all the time. I have a handout here. If you didn't get one, you can look at that. I've got a card. Oh, there's a question here, sorry. Oh, and then there's comments. Let's see. Okay. A question is, no one can contest the beneficiary you named. I think we answered that at the beginning. Anyone can contest for anything, but what if you move? What if you move states or move out of the country? Well, the laws of California state that if you set up a trust and a will in California, then those documents are valid in any state that you go to. So you're a resident of California, you establish your estate planning documents, you move to Tennessee and you die in Tennessee. Well, you have estate planning documents. Tennessee has to go by the California estate planning documents. It's required that Tennessee, that those documents are valid in Tennessee as well. That's what happens when you move. What if California unclaimed property ends up with trust estates and doesn't want to release the assets? So are you talking about, well, sometimes if you have no heirs that inherit your property, there's no one on that table of relatives, of heirs. Well, then your assets go to California, the state of California. And are you asking if they don't want to release it? Well, maybe someone came out of the woodwork and saying, well, I'm a first cousin.
Actually, I'm trying to get the assets and I've already filed for them. And California just does not want to release these assets. Is there any recourse? I'm the daughter, by the way.
You're the daughter,
Yes,
so the assets are held
by the state of
is it
California.
probate?
They're held by California unclaimed property.
Hmm.
They are all in a trust account.
In a trust account.
Yes, they are all trust properties.
Well, she's the daughter, but you're not named as beneficiary.
I don't, nobody has a copy of his will. We can't find a copy of his will, his trust, or anything.
Right. Well, I think it's got to go through probate. So maybe it's being held right now. The property is being held in the account, or wherever it is, until the estate can go through probate and the court can establish where it's going to go to. So you as a daughter will get it, but it's just got to go through that probate process first. So you can petition the court yourself or through an attorney. You can hire an attorney to probate your parents' estate, and then that money will go to you and the other heirs.
Does that money ever disappear, or does the state have to hold the money?
Yeah, the state holds the money until probate closes. It's not going to go anywhere.
Okay, thank you.
Mm-hmm. All right. Yes, absolutely. Yeah, I mean you can find templates of wills online, and it'll be valid. No, you can do your own. I mean, well, it usually states, this will is under the laws of the state of California, is my last will and testament. There's some things that need to be in there. Yes, I think so for the most part. Yes. A will form? Yes, I mean, you can search one up on Google, or go to an attorney. Our office has templates that we form. Yeah. I mean, that's what our firm does is, we have these templates of these legal documents that we set up, and then we customize it, yes. So that's